Thank you very much to the NVS community and to Jane for inviting me to give this talk. Today's presentation is a general overview of plant variety protection. That is the right to exclude plant varieties from the common use. What are plant varieties and why exclude them from common use are the main questions we will briefly deal today. It is very complex to speak about laws on plants. This is because plants embody life. The biology at the basis of plants, of life, the seed, is eternally evolving, while laws need to um, catch up with all this eternal evolution of biology and try to combine it with the interests of different stakeholders in plant breeding. And we would need different laws for different types of plants. So as you can see, this can be quite challenging, but we will not go so in depth today. We will start with a simple explanation of plant varieties. What are plant varieties? Before writing a PhD in plant variety protection, I thought that plant variety is everything that we find in nature. Maybe we have different vegetables or different roses, like we have here the varieties of the Rosa gallica. And if they cross, it's a natural process and the output would be an unexpected outcome. And these varieties are called heterogeneous varieties. However, for legal purposes, the meaning of plant variety is quite different. Varieties need to be uniform. They need to have the same characteristics that need to be reproduced over the years in a stable way. So why is there a need for a legal definition of plant variety? This is because agriculture is very important in our daily life, but agriculture is also business. And the moment that agriculture is a business, we need some rules in order to protect competition. And therefore, we started having plant variety laws. We will explain later how laws developed. But the question of what kind of laws do we need or how to protect plant varieties is a question that I believe will change over time with the change of interests and biology. It's difficult to give a definitive answer about the optimal law for plant variety protection. So how did these laws develop? Here we can see in this figure there are different centers of agricultural development. So we had different type of crops in different parts of the world. Before the world was not so globalized, especially if we think of the fact that people did not travel as we used to travel before the pandemic, and it was hard to get access to plants in other countries. Diplomatic missions were instrumental in accessing the plants grown in foreign countries, and these plants were taken for free and they were provided for free to farmers. An example comes from the US, where agriculture experimental stations were set for almost a century and allowed farmers to build agriculture in the country. And everything was for free in the beginning. However, it was farmers themselves, not only the government, but also farmers themselves, that after developing plant varieties over the years, they felt the need to distinguish their varieties from their competitors in the market or from their neighbors. And they used every tool possible. They would describe the varieties, the taste, or the appearance. Let's say the appearance of a tomato, if it was red or green, or the different type of taste that tomatoes might have, for example. And they also used paintings. This is very, very interesting. We can see here some pictures of different types of plants that had the function to distinguish these different types of plants. It was only with the development of an intellectual property system. So here on the right, we have a figure that represents the main rights in IP system. These rights not all of them apply to plant varieties. It was with the development of this system that plant varieties started to be protected by intellectual property laws. So what kind of laws do we have on plant varieties? Intellectual property laws are laws that allow the owner of the variety to exclude everyone from using the variety without the consent. But the situation in Europe is what appears in this slide. We have two main types of rights that are relevant in plant breeding. So we have plant breeders' rights, which started long before we had patents. And plant breeders' rights are the rights that reward the breeder for the efforts, not only the financial costs, but also the efforts, because a variety might take from 5 to 10 to 15 for 20, 25 years, and sometimes the output is unknown. So for the efforts in creating a new variety, an original variety that is different from previously known varieties. Now, this is a very simplistic explanation of what plant breeders' rights are, because obviously there are many legal requirements which the breeders need to comply with in order to obtain a right. But this system is basically called an open system because it allows the free flow of germplasm. How does it do that? Because the breeder who has the right on this original variety does not ask for a license from other breeders, farmers who use this variety in order to create new varieties. So if we have other breeders and farmers that need to use the protected variety in their breeding process, they don't need to ask for a license. They simply take the variety, improve, work on it, and only if there is a commercial, if their own final variety is commercialized and it's similar. Again, I'm using very simplistic term because if we go in depth, we have to discuss also what similar means. So that if this variety, the new variety created, is similar with the original variety, protected variety, there might be a license. License can be discussed. But mainly, the system is open. So even if something is protected, everyone can use it to improve on it. And this is how agriculture has developed. We all know that it's by seed saving and seed exchange that we started to develop agriculture. However, when patents were issued, they were not, this is a situation in Europe, not in the US and Australia and Japan and other countries, a little bit different. So when patents in Europe started to be granted, they were granted not on a plant variety, but on the DNA sequence that is inserted into the plant or in the breeding process. So on the left, we have two apples. One of them is brown and the other one is not brown. So these are, so the apple that is white, that remains white, is an innovation. This apple remains white thanks to a DNA sequence that grants the apple this property to remain white. And it's usually something that is highly innovative, something that tries to make a breakthrough innovation. In this case, something that does not exist in nature, because usually in nature apples would get brown. That is innovated. So it's the creativity and obviously the efforts that are put in the innovation process are rewarded through patents. But patents do not protect plant varieties as a whole, in theory. In practice, when we have patents on DNA sequences, the patent rights would extend everywhere this patent element, that is the DNA, is inserted and performs its function. So in practice, patent rights can extend to a plant variety. And the problem with patents, contrary, some call it problems, some might not call it problems, but contrary to plant breeders' rights, patents do not allow anyone to use freely the patented material. So if anyone would like or needs to use the DNA sequence in the breeding process, they would not be able to do so without a patent license. Now, what are the practical implications of this issue? Imagine a company, breeding companies, and these have been real problems sometimes, that needs to use a DNA sequence that grants the property to resist to a certain disease, the property to resist to climate change, let's say, then the moment this breeder finds out that there is a patent, needs to ask for a license. Now, it's not very simple because breeders usually do not have specialized lawyers, and they do not, especially small companies, they do not have specialized legal offices. So they do not know, most of the time, they do not know that there is a patent. And when they use the patented sequence, they might be, they will infringe. So this can be a real loss for them in terms of time and in terms of cost. And ultimately for the society, it will impede the arrival of new varieties, or it will delay certainly. Other issues is what happens in practice is that bigger companies can simply swap patents between them, and they simply do not reply to smaller companies. And this obviously delays and blocks innovation. And even if there is a negotiation between the breeder and a patent holder, it might be that the breeder doesn't have a negotiation power because it doesn't yet have developed a variety. So the patent right holder would be the one that um, would have more power and would probably even negate the patent because it cannot be sure of the commercial utility and application of its invention. So this situation was not very satisfactory for many breeders in Europe, and a few countries, Switzerland, France, Germany, and the Netherlands, changed their laws in order to introduce an exception to patent rights. That is, they try to make the patent system similar to the plant variety system. How did they do this? They allowed breeders to use a patented material in their breeding process for free. This would allow the free flow of germplasm between breeding programs, and if the final variety of the breeder would contain the patented trait, then a license would be necessary. But in this case, the breeder would be in a stronger position because it would certainly have a variety that can easily show the economic utility and the commercial application of this variety. This type of exemption to patent law is very important, and I know it has also been discussed in the UK, but it's not yet introduced into the patent system. The reason that this exemption is important is because it allows, as I mentioned, the free flow of germplasm between breeding programs, and at the same time, it might help having more innovation in the market and enhance biodiversity. However, finding a solution that satisfies all interests involved in plant breeding is not easy. In this slide, we have a few stakeholders. Corporations, which are the main stakeholders, they do invest heavily in research and development in plant breeding, and corporations are usually the one who have most of the patents on DNA sequence or that affect plant variety production. Small medium business can also have patents, of course, but they engage mostly in plant breeding, in crossing and selection, not in DNA sequence. So they do heavily rely on the plant breeders' rights system. And patents and plant variety rights heavily affect farmers. Now, Europe has always been very friendly with farmers, and we distinguish between large farmers and smaller farmers. There are different rules for different type of farmers, but the plant variety protection system seems to heavily restrict the right of the farmers to save seed and exchange seed. And this is how our agriculture system has evolved through centuries, through seed exchange and through seed saving. So this is a very important practice, which seems to be highly restricted nowadays. In Europe, we also have another type of farmer, this farmer that engages in breeding heirloom varieties, that is traditional varieties. The problem with these varieties is that they do not appear in the catalogs. There are some registers where seed needs to appear in order to be commercialized. And it's very challenging for those farmers. They are smallholders that engage in heirloom varieties. It's very challenging for them to market their varieties, and Europe doesn't yet have a clear law on this. And finally, we have the consumers. I believe that the interest of the consumers would be the interest of everyone involved in plant breeding, because consumers would love to have biodiversity in order to have higher quality and lower prices. The problem with biodiversity is that sometimes it has been argued, there are different studies, is that patents on plants and plant variety rights on plants seem to promote a uniform type of agriculture, not biodiversity. And those that endorse these arguments believe that there should be no intellectual property rights on seeds and plants. And indeed, in Europe, we have the open source license and the open source seed initiative in the US. In the US, the initiative relies on a pledge that's it's printed on the back, and they do prohibit farmers who make use of the pledge or of the open source license, or breeders. They are not allowed to patent or protect their varieties through plant breeders' rights, but at the same time, they are they are highly encouraged to seed to save seed and exchange seed among themselves in order to promote a traditional type of agriculture. Now, the problem with this type of model is that it works for small scale breeding, but it's very difficult to implement this model, because when we think of financing a global market, therefore, it doesn't seem to be a solution for every concern we have on plant breeding. Another solution comes from the industry itself. So we know Syngenta is a multinational, and it has created the international licensing platform for vegetable plant breeding that brings together different companies and organizations that engage in plant breeding. The motto of this platform is free access, but not for free. So the access, companies have the possibility, breeders have the possibility to see the different plant material that is available and to negotiate on the terms of accessing plant materials. If I am not wrong, the universities can access this platform for free, but it doesn't, of course, it doesn't go towards an open source system as promoted by open source licensing or open source pledges, open source models, sorry, in the US. But the system recognizes the patent and plant variety protection system, but at the same time, it asks for an opening of the system by allowing everyone who is engaged in plant breeding to have the possibility to promote the free flow of germplasm between breeding programs. Now, of course, the reach of the platform is limited if not every single stakeholder, global stakeholder, is included. But that's, of course, that would involve a lot of transaction costs, of course. But it can be a solution. So combining different types of systems. And indeed, we will have not a definitive answer on what is the best system to adopt for plant variety protection, but how can we have different systems that respond to different interests? How can we make these systems coexist? As we mentioned in the beginning, plant variety laws need to adapt to the evolving biology embedded in the seed and to all the interests that are involved. That is, we have traditional farmers, we have larger farmers, we have corporations, and we need to respond to all these interests in order to have an efficient supply of plant varieties for the global market. And this question is too complicated. Would be the answer would need another long presentation, but I'm looking forward to receive your feedback and to discuss plant variety protection.